Hi, this is Adam Stofsky with Briefly, and we're here with our next video with Inland County's Legal Services, this one on consumer debt cases. I'm here with Nicolas Villa, who's going to put this. So, Nick, start us off, because what is consumer debt? What are we talking about when we say consumer debt?
When we're talking about consumer debt, what we're talking about are those debts that were incurred for the sustaining of a household. Most often, we're talking about credit cards. Sometimes we're talking about auto possessions, repossessions. We could be talking about medical debt. Uh, what we see most often are credit card debt.
What happens when someone gets sued? How do you know you're being sued? Like, what's the process?
So most people know they're being sued when a process server actually comes to their house, knocks on their door, and hands them a complaint directing them to go to court. So there are two kind of phases of debt collection. One is the debt collection phase where they're sending you notices, they're calling you, trying to get you to pay, seeing if they can reach a settlement. And then there's another phase, which is where they've actually filed a lawsuit in court, and they're trying to get a judgment against you. In the first phase, my recommendation is to keep records, keep a call log for who's calling you, when they're calling you, what they're saying. And I would dispute the debt if you think that it is a debt that you don't know or want more information on.
Okay, but here we're talking about actual debt collection cases. So you've been sued, you get those papers from a process server. What are your options now? What do you do next?
You have four general options. Your options are to do nothing, in which case you'll lose automatically. You can try to call them to try to settle. You can answer the lawsuit and defend it, or you can look into filing bankruptcy.
Let's just take these one at a time. So the first option, default. I'm assuming that's just not a good idea, right? In most cases.
For most people, that's not a good idea. Yeah.
So what happens if you just don't show up?
If you don't show up after 30 days, the other side has the ability to file what's called a default, where you lose automatically. You lose because you didn't assert your rights in court. You didn't want to defend the lawsuit. In that case, a judgment is entered against you. A judgment in California is going to be good for 10 years, but it could be renewed for another 5 years. During that entire time, it'll continue to get interest.
And so they can just find ways to get the money from you at that point.
Once they have a judgment against you, they can take enhanced collection measures like garnishing your wages, levying your bank accounts, or putting liens on your property.
Okay, so basically a pretty much a bad outcome. So I think trying not to default is probably a good idea for most people, right?
For nearly everybody, I would not suggest default as a good strategy.
Okay, let's go to the next one then, which is actually trying to settle the case and negotiate. So what does this look like? What happens here?
Before you even entertain the idea of settling the case, I think you need to have an honest conversation with yourself and your household about whether settlement is something that you can successfully abide by. Once you have that conversation with yourself and your household, you would want to call the debt collection law firm, and you would want to see if you could settle for either one lump sum payment or a manageable payment plan. As a practice tip, you should know that your conversation is likely to be recorded and any admissions you make could be used against you later on down the line.
So an admission might be saying something like, "Hey, I'm really sorry I couldn't pay this. I know I owed it, but I just couldn't afford it at the time." Like, just don't get into stuff like that because you don't want to admit you owed the money, essentially, right?
Exactly. The other thing is you don't want to give them information that would make it easier for them to collect against you if they do get a judgment, for instance, where you're working, things like that, or where you're banking.
So you're calling it, and basically you decide, hey, I think I can afford $300 a month or something like that, and you say, here's what I can afford. Are you willing to accept this? Or like, hey, I know I owe $4,000. Would you take $1,000 now? Or you can make those kinds of offers, essentially, right?
Exactly. Exactly. It's really just a negotiation. There's nothing in the law that requires them to accept less than the full amount, but they oftentimes do. What you also should know, though, is that if they accept less than the full amount, there could be tax implications for that. And importantly, what I would want to say also is that any agreement that you make, you would want to make sure you get in writing or some memorialized in some way.
Right. So you can actually say, hey, no, we said this was a deal and I paid you off and it's done.
Exactly, and then make sure you're keeping records of any payments that you're making in case they say that you didn't make a payment when you were supposed to, et cetera.
Okay, great. All right, let's get to our third option, actually defending the lawsuit. So how do you do this and what happens here?
But in defending the lawsuit, you're filing what's called an answer. So they sue you with the complaint, you file the answer. There are several good reasons to file an answer. First and foremost, you avoid losing automatically. Because remember, if you do nothing, you'll lose automatically. By filing an answer, you avoid losing automatically. And at a minimum, that buys you several months, if not more, to figure out what it is you want to do with this debt, whether that's settling, whether that's looking into bankruptcy. But also remember that that these law firms sue people like you in this fashion by the thousands. And they have the burden of proving that you owe this debt in the amount that they say. So by making them prove it, oftentimes they're either unable to prove it or unable to prove it or unwilling to prove it. And if they're unable or unwilling to prove it, then they're not entitled to that judgment. They don't get that judgment. Also, it provides you the opportunity to try to appeal to a dismissal based upon your financial hardship. Essentially, you're saying, look, even if you get this judgment, it's going to be difficult for you to actually get any money from me. So would you please consider dismissing this basically in the interest of efficiency?
Let's talk about the fourth option, which you think you said was bankruptcy, right?
That's right.
Yeah, so
So
I
with
know it's
bankruptcy,
a scary word. So what does that mean here?
So with bankruptcy, bankruptcy is a very specialized area of law, and you would really want to talk to to a bankruptcy attorney to figure out whether you're able to file bankruptcy and whether you're able to achieve your objectives in filing bankruptcy. Bankruptcy could eliminate most or all of your debts, and you still could protect your home, your car, and other things that you want to protect. But again, you would want to talk to a qualified bankruptcy attorney to figure out whether or not this is a good option for you.
Okay. And so in court, I'm assuming you can win, right? And the judge would say, actually, that you don't know anything. Is that a possibility?
That is a possibility. But one thing that I would want people to know is that when you're being sued for a debt collection lawsuit, the relevant question before the court is whether you owe the debt, not whether you have the ability to pay. So if you go into court and say, yes, judge, I know that I owe the debt, I just don't have the ability to pay anything on the debt, that's really not a relevant question for the judge. The question is whether you owe the debt. And people I see often make that mistake, even in their answers to the complaint. They say, yes, I owe this debt, I just can't pay anything. And again, that's really doesn't get to the point of the lawsuit.
I just would like you to comment just quickly on what happens at the end of the case without going into too much detail. Did they just take your money then and there? What happens?
Yeah. So if a judgment is entered against you, again, the judgment would be good for 10 years, but can be renewed for another 5 years. If you have a judgment against you, really, there are three ways that they can go about trying to collect the money. They can garnish up to 20% of your wages. They can do a bank levy, or they can put liens on property that you own. Excuse me. There are different protections with respect to each one of those collection methods.
All right, before we finish up, any just practical tips for people who are going into this kind of situation? I know it's scary, but it does sound like there are actually a lot of options, whether it's just winning or payment plans. Any just practical advice for people?
Yeah, my practical advice, Adam, is don't ignore if you're being sued for a debt collection, or if you're being sued for a debt. Don't ignore it. Reach out to an organization like ours so you can understand your options. Adam, I'd also say that 90 to 95% of people who are sued in this fashion will lose by default because they don't participate. I think we need to encourage participation in the legal process, so people understand their options, so they have a voice in court.
Great. All right, Nick, thanks so much.
You're welcome, Adam.